guys, it's Franky. Welcome to the Think Tank. So, being that Lori Daybells' trial is coming up starting on Monday, I thought maybe we could go through the proposed jury instructions and the verdict forms, just to give us an idea of what they'll be looking at. So, let me bring that up. I found it really interesting. So, I've never been on a jury before, and I've never had a look at this kind of paperwork. So maybe you're the same as me. Let's check it out. So let's see here. The state of Idaho against Lori Noreen Daybell, aka Lori Noreen Daybell. This is her fifth marriage to Chad. The state of Idaho hereby files the following proposed jury instructions and verdict form, respectfully submitted on the 20th day of March, 2023. And of course, we've got the prosecuting attorney's name and no signature. I hereby certify that on this 20th day of March, 2023, that a copy of the foregoing state's proposed jury instructions and verdict form was served as followed. So James Archibald got one via email. John Kenneth Thomas got one versus email. Via email. So requested pre-vidoir instructions or proposed. So there is a bunch of different codes that I'm unfamiliar with. So they've got them all stated underneath here. I'm not even sure if each state has different codes. I suppose if they're federal charges, not, but. So this is for the instructions for the conspiracy. In order for the defendant to be guilty of conspiracy, the state must prove each of the following. 1, on or about October 16th, 2018 to January 15th, 2020, 2, in the state of Idaho. 3, the defendant, Lori Noreen Daybell, with Chad Daybell and Alex Cox agreed. 4, to commit the crimes of unaliving in the first degree of Tylee Ryan and grand theft by deception. 5, the defendant intended that at least one of these crimes would be committed. 6, one of the parties to the agreement performed at least one of these following acts. A, on or between October 26, 2018 and June 9th, 2020, Chad Guy Daybell and Lori Noreen Daybell did endorse and espouse religious beliefs for the purpose of encouraging or justifying homicide of Tylee Ryan. B, on or about August 16th, 2019, Lori Noreen Daybell did change the deposit of Tylee Ryan's Social Security benefits from Tylee Ryan's JP Morgan Chase account to deposit money directly into Lori Noreen Daybell's personal BBVA account. C, on or about September 1st, 2019, Lori Noreen Daybell did move from Chandler, Arizona to Rexburg, Idaho with Alex Cox, Tylee Ryan, and Joshua Jackson Vallow, or JJ. D, on or about September 8th, 2019, Chad Guy Daybell Googled South-Southwest wind and visited a website entitled, "What is the definition of SSW wind direction?" Or on about September 9th, 2019, Alex Cox did go to 565 Pioneer Road, apartment 175 in Rexburg, Idaho. F, on or between September 9th, 2019 and February 1st, 2020, Lori Noreen Daybell failed or refused to contact the Social Security Administration as required by law to inform the Social Security Administration of Tylee Ryan's death. G, on or between September 25th, 2019 and January 22nd, 2020, Lori Daybells, that's a mouthful, did wrongfully continue to collect 5 monthly Social Security survivors' benefits on behalf of Tylee Ryan. 7, and such act was done for the purpose of carrying out the agreement. If any of the above has not been proven beyond a reasonable doubt, then you must find the defendant not guilty. If each of the above has been proven beyond a reasonable doubt, you must find the defendant guilty. Okay, the next one is going to be on the first degree and the malice aforethought, including aid and abet language. So these will be the instructions. They've got, each count is broke down very nicely to give the jury a good explanation of the paperwork. Have you guys ever seen this before? Do you know if this is your standard type of form or instruction? So let's see here. In order for the defendant to be guilty of first degree with malice aforethought, the state must prove each of the following. So 1, on or about September 8th, 2019 to September 9th, 2019, in the state of Idaho. 3, the defendant Lori Daybells engaged in contact, oh good Lord, engaged in conduct or did aid, abet, advise, counsel, or procure another to engage in conduct which caused the death of Tylee Ryan. As usual, my tongue just gets all tied in knots. The defendant acts without justification or excuse. 5, with malice aforethought. And 6, the murder was a willful, deliberate, and premeditated killing. Premeditation means to consider beforehand whether to unalive or not unalive, and then to decide to do it. There does not have to be any appreciable period of time during which the decision to do this was considered, as long as it was reflected upon before the decision was made. A mere considered and rash impulse, even though it includes an intent, is not premeditation. If you find the state has failed to prove beyond a reasonable doubt any of the elements 1 through 5 above, or failed to prove any of the circumstances listed in element 6, you must find the defendant not guilty of first degree. If you find that elements 1 through 5 above have been proven beyond a reasonable doubt, and you anonymously agree that the state has proven any of the above circumstances under element 6, beyond a reasonable doubt, you must find the defendant guilty of first degree. You are not required to agree as to which circumstance under element 6 you find to exist. Okay, then. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of first degree. If you find all of the above to be proven beyond a reasonable doubt, then you find the defendant guilty of first degree. They're very, very aware of their wording, aren't they? Conspiracy in order for the defendant to be guilty of conspiracy, the state must prove each of the following. 1, on or about October 16th, 2018 to January 15th, 2020. 2, in the state of Idaho. 3, the defendant, Lori Daybells, Chad Daybell, and Alex Cox agreed. 4, to commit the crimes of unaliving in the first degree of Joshua J.J. Vallow and grand theft by deception. The defendant, number 5, the defendant intended that at least one of the crimes would be committed. 6, one of the parties to the agreement performed at least one of the following acts. A, on or between October 26, 2018 and June 9, 2020, Chad Guy Daybell and Lori Noreen Vallow did endorse and espouse religious beliefs for the purpose of encouraging and or justifying the homicide of J.J. Vallow. Their wording was, they were telling everybody that these kids turned into zombies. So is that what happens when you just decide you don't want them around anymore, or they start getting in the way? They turn into zombies. B, on or about September 1st, 2019, Lori Noreen Vallow Daybell did move from Chandler, Arizona to Rexburg, Idaho with Alex Cox, Tylee Ryan, Joshua J.J. Vallow. C, on or about September 23rd, 2019, Alex Cox did take possession of J.J. Vallow. D, on or about November 26th, 2019, Lori Noreen Vallow Daybell presided a false and or misleading physical location of J.J. Vallow to law enforcement during a lawful investigation. E, on or about September 23rd, 2019 and February 1st, 2020, Lori Noreen Vallow Daybell failed or refused to contact the Social Security Administration as required by law to inform the Social Security Administration of J.J. Vallow's death. F, on or between September 9th, 2019 and February 1st, 2020, Lori Noreen Vallow Daybell did wrongfully continue to collect 4 monthly Social Security survivors benefits on behalf of J.J. Vallow and 4 months Social Security child in care payments. 7, and such act was done for the purpose of carrying out the agreement. If any of the above has not been proven beyond a reasonable doubt, then you must find the defendant not guilty. If each of the above has been proven beyond a reasonable doubt, you must find the defendant guilty. This is going to be first degree with malice and forethought. This will probably be regarding to JJ. So in order for the defendant to be guilty of first degree with malice forethought, and state must prove each of the following. 1, on or about September 22nd, 2019 to September 23rd, 2019. 2, in the state of Idaho. 3, the defendant Lori Noreen Vallow Daybell engaged in conduct or did aid, abide, advise, counsel, and procure another to engage in conduct which caused the death of Joshua Jackson or J.J. Vallow. 4, the defendant acted without justification or excuse. 5, with malice forethought. And 6, the blank was a willful, deliberate, and premeditated act. Premeditation means to consider beforehand whether to do this or not, and then to decide to do it. There does not have to be any appreciable period of time during which the decision to do this was considered, as long as it's reflected upon before the decision was made. A mere consideration and rash impulse, even though it includes an intent, is not premeditation. So if you find the state has failed to prove beyond any reasonable doubt any of the elements 1 through 5 above, or failed to prove any of the circumstances listed in element 6, you must find the defendant not guilty of first degree. If you find that elements 1 through 5 above have been proven beyond a reasonable doubt, and you anonymously agree that the state has proven any of the above circumstances under element 6 beyond a reasonable doubt, you must find the defendant guilty of first degree. You are not required to agree as to which circumstance under element 6 you find to exist. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of first degree. If you find that all of the above have been proven beyond a reasonable doubt, then you must find the defendant guilty of first degree. So, conspiracy. In order for the defendant to be guilty of conspiracy, the state must prove each of the following. 1, on or about the 1st of October 2018 to January 15th, 2020, 2, in the state of Idaho. 3, that the defendant, Lori Daybells, Chad Daybell, and Alex Cox agreed to 4, to commit the crimes in first degree of Tamara Tammy Daybell. 5, the defendant intended that the crime would be committed. 6, one of the parties to the agreement performed at least one of the following acts. A, on or about or between the dates of October 26, 2018, June 9th, 2020, Chad Guy Daybell and Lori Daybell did encourage and espouse religious beliefs for the purpose of justifying and or encouraging the homicide of Tamara Tammy Daybell. B, on or about September 1st, 2019, Lori Daybell did move to Rexburg, Idaho with Alex Cox, Tylee Ryan, Joshua Jackson, or JJ Vallow. C, on or about July 30th, 2019, Chad and Lori sent text messages to each other regarding death percentages for Tammy and JJ. D, Chad Daybell obtained a burner phone on September 18th, 2019. E, Alex Cox obtained a burner phone on October 9th, 2019. F, Chad Guy Daybell and Lori Daybell sent text messages to each other about Tamara Tammy Daybell's being in limbo and Tammy being possessed by a spirit named Viola. Okay then. G, September 8th, 2019, Chad Guy Daybell signed an application along with Tamara Tammy Daybell to increase her life map insurance to the maximum allowed under her policy. H, Alex Cox attempted to shoot Tamara Tammy Daybell on October 9th, 2019. What was up with Alex Cox and his sister? Can anybody explain that to me? Because, whoa. So Alex Cox conducted multiple internet searches between the elates of October 8th, 2019 and October 12th, 2019, including searches related to Grendel Drop and shooting through a Dodge Dakota. J, Alex Cox went to a gun range in the months before October 9th, 2019, when the attempted shooting of Tamara Tammy Daybell takes place. K, Alex traveled from Sportsman Warehouse to the vicinity of the Daybell residence on October 9th, 2019. L, Alex was in the church parking lot approximately 2.5 miles from the Daybell residence on the night of October 18th, 2019. 7. And such act was done for the purpose of carrying out the agreement. If any of the above has not been proven beyond a reasonable doubt, then you must find the defendant not guilty. If each of the above has been proven beyond a reasonable doubt, you must find the defendant guilty. So this one is going to be for grand theft in alternative theft by deception. I have not seen anything yet for Chad Daybell's instructions. I'll be very curious to see how close they are to the instructions here for Lori Daybells case. So in order for the defendant to be guilty of grand theft, the state must prove each of the following. On or about the dates of October 1st, 2019 to January 22nd, 2020, 2, in the state of Idaho. 3, the defendant Lori Noreen Velo Daybell wrongfully took, detained, or withheld property described as Social Security survivors' benefits allocated for Tylee Ryan and JJ Velo, and Social Security child in care benefits allocated for Lori Noreen Velo, to which funds Lori Noreen Velo Daybell was not entitled. 4, from the owner. 5, with the intent to deprive an owner of the property or the appropriate the property. And 6, the property exceeded $1,000 in value. Or in the alternative. Okay, instruction. In order for the defendant to be guilty of grand theft by deception, the state must prove each of the following. 1, on or about the dates of October 1st, 2019 to January 22nd, 2020. In the state of Idaho, the defendant, Lori Noreen Velo Daybell, obtained or exerted control over Social Security survivor benefits allocated for Tylee Ryan and JJ Velo, and Social Security child in care benefits allocated for Lori Noreen Velo in the amount exceeding $1,000, to which funds Lori Noreen Velo Daybell was not entitled to. 4, another person was the owner of such property. Number 5, the defendant did so by knowingly doing one or more of the following. A, creating or confirming another's impression which is false and which the defendant did not believe to be true. Or B, failing to correct a false impression which the defendant previously had created or confirmed. Or C, preventing another person from acquiring information relevant to the disposition of the property. Or 6, the defendant had the intent to deprive the owner of the property or to appropriate the property to the defendant or to some person other than the owner. If any of the above has not been proven beyond a reasonable doubt, you must find the defendant not guilty of grand theft. If each of the above has been proven beyond a reasonable doubt, then you must find the defendant guilty of grand theft. So, theft, different forms possible. There are different forms of theft depending on the manner in which the theft was committed. The defendant, Lori Noreen Velo Daybell, is charged in count 7 with the theft of Social Security funds. The state alleges that such theft was committed either by taking, withholding, or detaining said property, or by deception. If you are satisfied beyond a reasonable doubt and unanimously agree that the defendant committed the crime of theft, you should find the defendant guilty. You are not required to agree as to the particular form of the theft the defendant committed. So basically, everybody just has to agree, regardless of which precise thought or statement, or they don't have to agree on that. They just have to agree that it was done. So in the District Court of the 7th Judicial District of the state of Idaho, in and for the county of Fremont, the state of Idaho versus Lori Noreen Velo, aka Lori Noreen Daybell. We, the jury, do impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Question number 1. In regards to count 1 of the indictment, is Lori Noreen Velo Daybell guilty or not guilty of conspiracy to commit first degree of Tylee Ryan and grand theft by deception? And then the guilty or not guilty. Question number 2. In regards to count 2 of the indictment, is Lori Noreen Velo Daybell guilty or not guilty in the first degree of Tylee Ryan? Question number 3. In regards to count 3 of the indictment, is Lori Noreen Velo Daybell guilty or not guilty of conspiracy to commit first degree of Joshua Jackson J.J. Velo and grand theft by deception? Question number 4. In regards to count 4 of the indictment, is Lori Noreen Velo Daybell guilty or not guilty in the first degree of Joshua Jackson Velo? Question number 5. In regards to count 5 of the indictment, is Lori Noreen Velo Daybell guilty or not guilty of conspiracy in the first degree of Tamara Tammy Daybell? Question number 6. In regards to count 7 of the indictment, is Lori Noreen Velo Daybell guilty or not guilty of grand theft? And then the juror. So burden of proof. It is presumed that no statutory aggravating circumstance exists in this case. This presumption remains throughout the sentencing hearing and during your deliberations. That presumption cannot be overcome unless from all the evidence you are convinced that one or more of the alleged statutory aggravating circumstances has been proved beyond a reasonable doubt. The state has the burden of proof for proving the existence of statutory aggravating circumstances, and that burden remains on the state throughout the sentencing hearing. The defendant is not required to prove the absence of any aggravating circumstances, nor is the defendant required to produce any evidence at all. Reasonable doubt is defined as follows. A reasonable doubt is not a mere possibility or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Aggravating circumstances. You're instructed that the charged statutory aggravating circumstances are simply allegations that are not evidence. No juror should be influenced or prejudiced for or against the defendant because of the fact that the penalty is being sought. So in this particular case, as far as Lori goes, there is no D penalty. I don't know how it'll work for Chad Daybell. That's something totally different. The state alleged the following statutory aggravating circumstances. D, the murder was committed for remuneration or the promise of remuneration, or the defendant employed another to commit this for remuneration. Remuneration. My tongue again, guys. My tongue again. Or the promise of okay, I'm not going there. My tongue's not doing it. You know what I'm talking about. Is there any kind of gain? E. The unaliving was especially heinous, atrocious, cruel, manifesting exceptional depravity. F. By unaliving or circumstances surrounding its commission, the defendant exhibited utter disgrace or disregard for human life. Absolutely, all of the above. The defendant, by his/her conduct, whether such conduct was before, during, or after commission, has exhibited a propensity to commit, which will probably constitute a continuing threat to society. If you unanimously find that one or more of the aggravating circumstances exist, the law requires you to reduce such findings to writing by stating specifically what aggravating circumstances or circumstances exist, if any. This finding must be part of your verdict. If, after considering all the evidence, you unanimously conclude that there is reasonable doubt after the existence of statutory aggravating circumstances, you must indicate on the special verdict form, by statutory aggravating circumstance has not been proven. You must indicate this finding by checking the appropriate box next to such aggravating circumstances or circumstance on the verdict form furnished to you. If you cannot unanimously agree on whether an aggravated circumstance exists, you must so indicate. The verdict form must be signed by your presiding juror. Definition of that for remove. Okay, give me a second. Let me just see if I can untie it. Remaneuver. I'm leaving it alone. Okay. To prove the defendant committed this or aided and abetted another for, or the promise. I think this is all. Yes, it means payment or compensation, just to make it a little bit easier. My tongue doesn't want to do that. So basically, financial gain. Jury deliberations. In reaching your verdict, you must first decide whether the state has proven beyond a reasonable doubt that any of the statutory aggravating circumstances exists. You must consider each of the alleged statutory aggravating circumstances. Your decision as to the existence of each statutory aggravating circumstance must be unanimous. If you find that the state has failed to prove the existence of any statutory aggravating circumstances, or if you're unable to unanimously agree on that issue, you must say so indicated on the verdict form. You must so indicate on the verdict form. If the state has failed to prove the existence of statutory aggravation circumstances, you need not deliberate further. You'll notify your bailiff that you are done. The judge must then sentence the defendant to life in prison, as a judge must set a fixed period of imprisonment from anywhere from 10 years to life, during which the defendant will not be eligible for parole. If you unanimously find that the state has proven the existence of statutory aggravating factors, then you must so indicate on the verdict form. You must also then consider whether any mitigating circumstances exist that make the imposition of the death penalty unjust. If you find that all mitigating circumstances are sufficiently compelling to make the defendant, to make the imposition of that, okay, we know that they don't have that penalty. Okay, this is basically all talking about that. So we know that, again, it is off the table. So if verdict form. Part 1, we the jury render the following verdict regarding the alleged statutory aggravating circumstances. A, has the state proven beyond a reasonable doubt that the death of Tylee Ryan was committed for money? No or yes. Unable to reach a unanimous decision. And it looks like those will be all of our options all the way through. Has the state proven beyond a reasonable doubt that the death of J.J. Vallow was committed for money? C, has the state proven beyond a reasonable doubt that the unaliving of Tammy Daybell was committed for, do I say money, financial gain? D, has the state proven beyond a reasonable doubt that the death of Tylee Ryan was especially heinous, atrocious, or cruel, manifesting in exceptional depravity? E, has the state proven beyond a reasonable doubt that the murder of J.J. Vallow was especially heinous, atrocious, or cruel, manifesting exceptional depravity? F, has the state proven beyond a reasonable doubt that the death of Tammy Daybell was especially heinous, atrocious, cruel, manifesting exceptional depravity? G, has the state proven beyond a reasonable doubt that by the unaliving or circumstances surrounding the commission, the defendant exhibited utter disgrace for human life? H, has the state proven beyond a reasonable doubt the defendant, by her conduct, whether such conduct was before, during, or after the commission of the unalivings at hand, has exhibited a propensity to commit death, which will probably constitute a continuing threat to society? If you answered either no or unable to reach a unanimous decision to each of the above questions, you do not need to answer any of the other questions. Simply have the presiding juror sign this verdict form and notify the bailiff that you are done. If you answered yes to any of the above questions, then please answer the question in part 2. Part 2, answer only the questions that concern a statutory aggravating circumstance you have found to exist. We, the jury, render the following verdict regarding the weighing of all mitigating circumstances against the statutory aggravating circumstances. A, with respect to statutory aggravating circumstances, that the death of Tylee Ryan was committed for financial gain. We find that when weighed against the aggravating circumstances and all mitigating circumstances are sufficiently compelling that, okay, and we're getting back into the DP, so we'll stay out of that. Okay, and this is all DP information, and again, that is not going to be considered in this, in Lori Vallow's side of things. Chad, now I can't say. I don't know what they're going to do with that case. Wouldn't surprise me if they went that direction, though. And I'm just going to see here. Yeah. Again, we're talking about the DP, and that is not going to be looked at. So the paperwork can be dry, but it does give us, in my opinion, it gives us a really good look at what the actions, the results might be. Some heinous things were done. Children died. Adults died. And they are saying that Alex Cox, over here, her brother, has had a lot to do with most of these. And then they're also saying that when he passed away, it was of natural causes. So this is her husband that her brother Alex unalived. So Chad Daybell and his wife, may she rest in peace. All of this death around these people, unreal, unreal. So let me know, guys. I just thought it would be something nice to go through so we've got a clue as to what they might be looking at. For each of these, this is just an outline. It's not written in stone. They're still talking about the DP penalties. So if that's going to happen, it'll happen on Chad Daybell's side, not on Lori's side. It's already been taken off the table. So guys, that is what we have for now for an example of what the jurors will be looking at. If anything a little more clear comes out, or if they've adjusted anything that I find, I'll throw that paperwork up too. There is so much paperwork on this case. It is unreal. Thousands of pages, literally. So I'm slowly wading through those to see which is applicable and which isn't now, and what information we may have forgotten about it over the last couple of years. So guys, thanks very much for spending the time with me, and I'll absolutely see you in the next one.